morning and a very warm welcome to today's event by Indian Lawyers Association. Especially the efforts have been put in by our Mumbai chapter. And we are here to focus on the new criminal laws. We have a wonderful panel with us today, moderated by Prachi. Just a minute about what ILA is. So, ILA is a pan India organization which is here to kind of strengthen India's legal system by way of working in a community network based model, and we operate by way of having different chapters across the country. So we have about 80 chapters so far. So each chapter adds in a lot of local flavor to how the ILA chapter grows in their own city. So if you are interested to join ILA, we would be very interested to welcome you. We would have a lot of viewers from YouTube today. So also mention to them that do put in your comments, and from where you are, if you're interested to join, please feel free to connect with us. So before we start, please allow me to introduce our moderator for today, Prachi Pandya. So she's practicing in the Bombay High Court since 2004. Her area of practice includes corporate, commercial, and capital market litigation, including white-collar crimes. She extensively advises and regularly appears in statutory arbitration conducted by the stock exchanges and depository participants. She also represents clients in quasi-judicial proceedings before SEBI and Security Appellates Tribunal. Prachi also appears in a gamut of proceedings before NCLT. Over the years, he has appeared in several domestic and international arbitration matters, both institutional and ad hoc. A regular speaker at various conferences and seminars, Prachi has been invited by prestigious bodies such as the Institute of Chartered Accountant and Company Secretaries. Prachi is also on board of the ILA's Mumbai chapter. Prachi, thank you so much for agreeing to do this, and I hand it over to you now.
Thank you, Madhura, and always a pleasure. The topic was very interesting, so I couldn't have let it go on. So, as you all aware, we have now the two new criminal acts. The Indian Penal Code has been replaced by the Nyaya Sanhita, and the CRPC has been replaced by the Bharatiya Nagarik Suraksha Sanhita. It came about on the 1st of July 24. And it's about 3 months old. So the whole purpose of this chat today and discussion was to evaluate in the last 3 months how the act has fared. We as practitioners, what have we learned, the pitfalls, some new learnings. So this was the whole purpose of today's discussion. And to begin and set the tone for today's discussion, let me read out the statement of objects of the BNSS. And it states, and I quote, "Fast and efficient justice system is an essential component of good governance. However, delay in delivery of justice due to complex legal procedures, large pendency of cases in the courts, low conviction rates, insufficient use of technology in the legal system, delays in investigation system, inadequate use of forensics are the biggest hurdles in speedy delivery of justice, which impacts the poor man adversely. In order to address these issues, a citizen-centric criminal procedure is a need of the hour." So let's evaluate whether this act addresses all these issues. And to do that, we have Devansh Mohta and Ashwin. And before we begin, let me have the privilege to introduce both of them. Devansh is practicing in the Supreme Court and invite ranges of matters from criminal, civil, constitutional, and arbitration as well. He's a member of the Chartered Institute of Arbitrators and also on the reserve panel of the SIAC, that is the Singapore International Arbitration Center. Recently, he's been appointed as an amicus in the matter of Sonadhar versus State, dealing with Supreme Court's project on e-prison. And Devansh, I'll come to you in much detail because I want you to address what you're doing in this matter because it has direct bearing on the discussion we are having today. Ashwin has nearly 2 decades of practice in the legal profession. His forte lies in criminal laws and white-collar crimes. He's also on this special counsel for the state of Maharashtra and appears for the state and also for various departments of the state of Maharashtra. His forte lies in complicated criminal trials, and he's appeared in a gamut of matters ranging from PMLA, TADA, Maharashtra Control of Organized Crimes. Also, he's appeared in various front page matters involving NACL, NPID cases, the Aryan Khan drug case, the DHFL money laundering case, so on and so forth. So on a lighter note, if you want to know what Ashwin's day looked like, perhaps just open the morning newspaper.
That's very kind of you.
So on that note, gentlemen, before we deep dive in specifically into each of the issues, your first thoughts on, because we'll be focusing more of the BNSS on the procedure. Do you think a new law was required at all, or the earlier CRPC could be tweaked? And now that we have a new law, do you think it's a new wine on the table or just a new old wine in a new bottle? So your first thoughts, perhaps you could start with Devansh and then Ashok can take over from there.
So the question whether the new law was required or not is very difficult to answer. And largely it depends on how it will serve the utility, because one can't say that the law which is passed has nothing new that they are trying to bring in. One, of course, some part of this legislative exercise is also to consolidate judgments of the court or the amendments which went by between 73 and 2020, 2018, etc., etc. So that effort of consolidation has been done. Can you criticize or can you comment upon an effort to consolidate 50 years of working of a previous law? Perhaps not. Were we expecting that a new criminal law should have looked absolutely different? And was there a reason that if at all a new criminal law came by, should it have had absolutely dynamic and different body or structure, which could mark a milestone change in the criminal setup? Was that required? Was that expected? Perhaps not, because there is no reason to do that level of overhauling of criminal law. But there are certain new things that have been factored in. For example, time limits have now been prescribed for completion of trial, delivery of judgment. There is emphasis on technology that has been brought about, which I think is a need of the time. So that one can see now writ large within the statute. Not that this provision was not there earlier. There are judgments of the court which had recognized conduct of trial by video conference and etc. But now there is statutory recognition to that. Some provisions which we will discuss in the course of our chat today, whether they are good provisions or bad provisions, one will have to see over a period of time. So to answer your question, whether there was a need to overhaul, that is difficult to answer. But was there, does it meet the expectation that now after 50 years, if there is a new criminal statute, should it look absolutely different than as compared to 1973? I don't think it should. That should be, that's not a very reasonable expectation that there should be total overhauling and only then there is a need to bring about a new law. But we must focus on the new things that have come and perhaps give the law an opportunity for working itself out and to see if the new interventions which have come by, have they been able to serve the main purpose of the statute, which is speedy justice, efficient delivery of justice, reducing time in completion of criminal trial, etc., etc. That I think one will have to wait and watch. While we can focus on certain aspects in our discussion on whether some new provisions are good or bad, that we will discuss when the statute comes. So this is my preliminary comment on the new law.
So the key takeaways, a lot of the judgments have been now incorporated, which was scattered in various judgments in now this act.
So there is an effort of consolidation. Some of if you see that even the statute, the way it has been numbered, some of the provisions which were added as A, let's say some number A, B has now become a separate number and things like that. That's why the numberings have also changed. So that exercise has happened. Now that is a semantic exercise. But the main point is, what was the expectation between 1973 and 2023? After 50 years, if you're bringing about what you call as the new criminal law, should should that be a complete dynamic shift from the existing criminal procedure or not? That is the fulcrum. How different should it look from the 1973 Act for it to be accepted as a good legislative step is a question which is very difficult to answer, according to me.
Deep dive further. Ashwin, your first thoughts on the Act, especially the BNSS?
Look, I think it's again, as rightly pointed out by Devansh, I think this is an answer that will be subject to each one's own understanding of how they've dealt with the laws so far. And I think it is for our audience to really mull over it. Look, it's been a long journey for these laws since over a century. For example, the old Indian Penal Code was 1860. All these are very old laws. I think they were formulated after studying certain basic human tendencies, the manner in which certain offenses are committed. And I think after studying all that, this particular formulation had taken place. I think when one is expecting, or when one is talking about an overhaul of the entire criminal justice system, I think the journey that has taken the legislators where they stand is, the journey that the laws have had so far over a century or decades or whatever, where they are standing, what is the current contemporaneous position of the society, of the manner in which the society is thinking, and the prevailing circumstances. And in addition to that, where is the society going? What are for example, in our very lifetime, we have seen the efflux of technology and the manner in which technology, in fact, I feel that with the manner in which the Supreme Court is also pushing things, there is a very likelihood that technology will take the Supreme Court, in fact, to the last taluka, right, for a hearing. So that is the manner in which the technology is traveling. We are now talking about online frauds, online banking frauds, etc., and everything. So I think the legislators ought to have actually studied how much have we traveled, where are we at, and what in the future. Because look, the legislators do have certain privileges about having various empirical data as to what are the things which are likely to come in the society or which they're ushering into the society. I think to a large extent, they could have maybe done a lot more. And taking a look at these laws, I think a lot was desired to be done. A lot could have been done, and a lot desires yet to be done. I'll give you one very simple one. I don't understand. Do we really, in today's day and age, really need to debate marital rape? I mean, consent is something which is so natural to human rights as of today. After such a long discussion in the Supreme Court about all these laws and about having this, do we really need to actually come back and see whether marital rape needs to be brought in? I think that, these are the issues which could have been addressed. So I think, given where our society is going, look at the manner in which the old 377 has been addressed. I mean, it has been completely done away with. I mean, today, therefore, if a man gets sodomized, he has no forum. There's no offense. I mean, that's what I'm saying. That I think I really don't know how much these three laws, especially when you're talking. Look, all these. There are two ways of bringing in changes in laws. One is that you amend and you bring in. For example, the Lalita Kumari judgment spoke about preliminary inquiry, spoke about a zero FIR. Then there were amendments to the law. They were brought in, 41A and all those things. The law commissions reported, discussed it, and consequent to that, there were amendments to it. Now, when you are bringing in you have an opportunity of bringing in a completely new law. Okay. Would it be the question that we need to ask ourselves? Would it be enough to only encompass what the judgments or the judicial jurisprudence has recommended, or do we need to do more? I think that's the question that all of us need to ask ourselves when we are analyzing this. and maybe even our legislators.
Some very interesting points raised. Now, diving a little deep on the specifics now. One of the observation I did in reading of the BNSS was a fact and one of the provisions that the police officer in charge has the power to investigate in cognizable offences even without an order of the magistrate. Now, Ashwin, your thoughts first. Would you agree to the power handed over to the executive and the law enforcement machinery, or you would say that this has to be treated with caution?
Look, I think the answer is a very valid. Sorry, the question. Let me actually start with the question. The question is a very valid question. I think the question falls from maybe a layman's perspective, because usually we see in movies that, oh, the cops are come, and then you ask the cops, kya tumhare paas court ka order hai? That's not how things work. Look, if there is a cognizable offense that has taken place, okay, the police have the sweeping power to initiate investigation, to enter into premises, to freeze accounts, everything. The old law or the new law, they did not really bring in the participation of the judiciary in an investigation. Okay, that has never been the case. That is not what this law even tends to do. Of course, in a non-cognizable offense, because these non-cognizable offenses are usually offenses which are very trivial in nature.
Yes.
And there maybe the state feels that the wherewithal or the state exchequer really does not need to get into by expending their energies and their monies. So that is where the order of the magistrate was required under the old legislation, the 155 and all those. But even the new law, but I'll tell you what the new law does. I think this is a very, very interesting thing that I would really like to point out. And I think that is where there has been a drastic change in the approach of the criminal justice system over here. You see, and a person who is going to be accused, okay, had absolutely zero audience before the criminal justice system could be initiated against. Okay, so for example, there are two main ways in which the criminal prosecution could start against a person. One is an FIR, and second is a private complaint. Now, the FIR, you go to the police. Okay, if he does not register, you go to the magistrate and you take a order from the magistrate that you please register an FIR. That was the procedure to start an FIR. Okay, then if it's a private complaint, then you go to a magistrate. He analyzes he scrutinizes the complaint. He takes your verification or not, and he issues process. There was never any question of any arrest or anything in a private complaint. Now, again, until the magistrate does not issue process, okay, the accused person had no audience before the magistrate, none whatsoever. Okay, yes. He had to read it. He had to conduct his own inquiry. He could close it under 203, but the accused had no participation. FIR, the police is expected to, if the moment there is a cognizable offense, as Lalita Kumari has reiterated time and again by the Supreme Court again, is that the moment there's a cognizable offense, please register an FIR and then you start the proceeding. And what used to happen is that having an FIR or a criminal proceeding act obviously is stigmatic in society. So what Lalita Kumari's judgment did was introduce the concept of preliminary inquiry. That you please reach out to the other side and see and things like that. But private complaint, again, and there used to be instances where maybe half-truths were brought before the magistrate, and again, our criminal justice system used to start. What the new laws tend to do, okay, is that they have codified the preliminary inquiry system where before registering an FIR, where there are offenses of 7 years, okay? And for the private complaint, what they have done is that they have mandated the participation of an accused person. So now what the magistrate is supposed to do is that once he gets a complaint, he's supposed to reach out to the other side, also hear him out, and on scrutiny of both their material, then he says whether an offense is made out or no. I think what both these things tend really to do, a little more could have been done. I'll just speak that after I finish this, is that it tends to give the machinery the opportunity to scrutinize both sides and see whether a criminal proceeding even needs to be initiated on.
Yes.
So it nips the bud at the initial stage only. You know, in Singapore, like as I said, if you go to the police and the police does not register your FIR, you go to the magistrate, right? Under 156.3, old 156.3 here. Again, that whole system is there. But in Singapore, what it, or one of some of the other jurisdictions, what it does is it allows the magistrate to even call the other side and see if it could be settled. You know, again, trying to resolve criminal disputes. You know, because the fact remains that today's jurisdictions have a lot of civil-natured criminal disputes. You know,
Yes.
forgery, cheating. The magistrate, therefore, is given that liberty that, come on, if you can, let's sit on the table and you close it. You know, I really don't see it. That is something that could have been taken from that jurisdiction, because I think the rest of the section deals almost identical to the section which exists in a jurisdiction like Singapore. You know, so I think more could have been done. Yeah, but as I said, the overhaul is so good that it actually gives the machinery now a perspective of the other side, and then think about whether a criminal proceeding really needs to start or no. So, coming back to your question, police never needed the permission of the court in case of a cognizable offense. All they had to do is send a copy of the report immediately, but they could always immediately start investigation. What this law again adopts is the Lalita Kumari principle of zero FIR. So, irrespective of your jurisdiction, you can register your FIR anywhere and then transfer it to whoever is the current relevant jurisdiction.
So it's a very interesting introduction of hearing the accused as well at the time of initiation. That's I appreciate. Devansh, your thoughts on this point, you know?
So Ashwin has covered the ground, and this was one of the example of consolidation.
Right. Yes.
So you know, the Lalita Kumari, which emerged out of ultimately setting criminal law in motion, which may violate somebody's freedom. But moment you set criminal law in motion, there is an element of Article 21 that comes into play. Now, this preliminary inquiry principle, which was read in through Lalita Kumari, now with this codification, is that bringing in line that consolidation of existing legal principle between 73 and 2023. So this is one such example of consolidation.
Right. Right. Yes. So
This,
I
this
thought of
that's right.
that came to mind immediately. Consolidation when Ashwin was mentioning about how the judgment has now been what more crystallized in the act itself.
That's right.
The other point I want to draw and have your thoughts on the issue of remand. And there's a lot of conundrum about it. I've been reading certain articles about it. In fact, some articles that I read saying that certain legal and civil activists are saying that certain provisions on remand is, if I can quote, retrograde provisions. Is your reading of Section 187 of the BNS is similar? Do you think retrograde? It is similar to what it was, is just being crystallized now. So practically, Ashwin, because you did on a trial basis or a daily basis, do you read 187 as retrograde?
No, I think. Look, I think we have been. I think if legislators, the courts have been struggling with this aspect, which used to be 167 once upon a time. Look, I think the expectation is that the moment an offense gets committed and it gets reported, okay, it has to be attended to immediately, as expeditiously as possible, so that the evidence is preserved, okay, because and no further damage to the entire scenario or the offense is, or the consequences of the offenses are also contained, you know. But the primary reason is that, see, you must have heard this, that the first 72 hours, the first 48 hours are very crucial to an investigation, right? But then at the same time, today when we are living in a technology or a white collar a flux of white collar crime related society, okay, is this 72 hour or 48 hour that crucial? Okay, So that becomes the primary question. See, because at the end of the day, you keep any accused in custody for 1 day, 20 days, 40 days, 60 days, whatever. But anyways, can't use his statement. The Constitution has protects the person. So no matter what you bring, whatever you take down from him as a statement or whatever, it is not something that you really can use unless it is one of those recovery panchanamas, right? Where something else is to be recovered. But again, whatever he says which incriminates himself can never be used. So in blue-collared matters, it was expected that the investigation should get finished within 24 hours. Then it was thought to be 15 days, then 60 days, then 90 days. Then what was seen that the moment, and as we all know, that the moment a prosecution starts, one of the main things that a lot of accused person use or tend to misuse is that, oh, I'm not feeling well. I have a chest pain. I'm not in a position to answer your questions or anything like that. And then they go to they are taken to the hospital or something like that, and they sit there and avoid the. So what used to happen is that the police were not able to interrogate or investigate very effectively. And as I said, the first 72 hours, 48 hours could be very crucial. And if within that period, if he's resorting to something like that, okay, uh, their 15-day period to actually interrogate him, okay, effectively used to get wasted because he used to be taken to the hospital. So recognizing this new trend that was evolving, the Supreme Court had already started addressing this issue, and you will see the traces of it in the judgment of Senthil and those, right? They had started addressing it. That the first 15-day period where the police have the liberty to keep the person in his custody, okay, and interrogate him effectively so that they can gather as much evidence as possible, can now be broken. So, for example, if he says, I'm not feeling well, so he will be taken to the hospital 3 days. Okay, let us assume the government hospital says that he's perfectly all right. Now you can take him back. There's nothing wrong with it. Okay, so then those 3 days, okay, will not be used towards the 15-day period. Correct. Which the police have. Correct. All of this has to be done within the 45 days. Like this breaking up of the initial 15-day period has to be done within a 45-day window. Because correct. What happens is, if they do not file a charge sheet within 60 days, then the accused gets the privilege of getting what they call a default bail. If the police file something called a challan, then obviously they don't get. And if the punishment is more than 60 days, more than 10 years or up to 10 years, then it is 90 days. So, but that is of judicial custody. So if I can just break it up, arrest, 15-day with the police at the most, then so that he should not flee or tamper with evidence and all, he stays in judicial custody. Unless the magistrate or the judge feels that he can be granted bail, right? So the 15-day period now has been preserved by way of breaking it up within the first 45 days. And if they still are not able to file a charge sheet within 60 days, and if the accused tends to exercise his right first before the police, then he gets default bail. So I wouldn't really say that this is retrograde as such or regressive as such. I think to some extent, given the new trends of investigation, okay, I think some elbow room will have to be done, and we'll have to see how this law evolves. Because as I said, there have been several amendments to it, and there is a lot of evolving that has taken place in relation to this particular section. Right?
So again, coming to Devansh's point of consolidation, it appears that Senthil has been, crystallized here, Devansh.
But as far as remand, there are just 2 or 3 points that I wish to highlight here. Earlier, this period was considered 15 days. So one would generally see orders that the immediate first order of remand was for a period of 14 days. Then there was also some debate about what is the extent of police custody you could have. Could you have police custody more than 14 days? Could you have, or should it be only judicial custody? The earlier provision of remand also used to, within the proviso, had an expression otherwise than in police custody, which was always being interpreted that once you have completed the statutory minimum, police custody should not be granted. Now, what they have done, at least by the reading of 187, that perhaps there is now a discretion for the magistrate to say that that 15 days is the period. The clock will start ticking from the date of arrest. Then, depending on the gravity of the offense and your maximum period within which you can be kept in remand, you have the 40-day or a 60-day within which this 15-day period has to be completed.
Correct.
But you don't have to immediately pass an order of a 14-day remand. You can pass an order of a shorter period. The other thing is that they have now done away with this distinction of judicial custody, police, in the sense they have this provision of otherwise than in police custody now, I think, has been merged in a section which only now provides the meaning of a judicial custody and a police custody. Now, that discretion lies with the magistrate, who can keep alternating between judicial and police custody.
Right.
So it may now very well happen that the magistrate may have the discretion that he can send a person to first judicial custody, then police custody, or alternate between the two. That discretion, if there was any doubt, has now been clarified that the discretion is there. The criticism, I think, that came about as soon as this law was passed, that the possibility of misuse, that you will keep people behind bars intermittently, take them out, put them in, take them out, put them in, that may happen. And how would you then, this can also be a weapon of misuse.
Yes.
But there is no provision of law which cannot be misused. Now, is that the only ground on which, because of its misuse, should it be set retrograde? Perhaps not. I would agree with Ashwin that it's not on the face of it retrograde. It is attempting to balance the power of, ultimately the main fundamental reason of the whole provision of remand, which is a pre-charge sheet, is to ensure that the investigation is facilitated.
Yes.
So that facilitation of investigation versus right of an accused and his liberty, which is taken away moment he is arrested. I think there is an attempt to balance it. There's an attempt being made to balance it.
Correct.
So that the arguments, technical arguments of nature of custody or time spent in the police custody, which was actually in police custody, but moment you were taken by the police, you got hospitalized.
Correct.
So there was never an opportunity of actually investigation, but the 7-day, 8-day period was over. Then what do you do? So matters have traveled to Supreme Court, where they have then asked for the 7-day calculation, counting the 7-day from the time the person got discharged from the hospital. That our 7 days were never done. Now, all these things will, I think, perhaps maybe a way to put pressure on all the machineries to be timely, efficient, quick, swift, because there is a clock which is ticking of 40 days, and there is a within 40-day a period of 15 days,
yes,
where you have to complete without raising any technical argument of judicial and police custody. So I guess it's not retrograde, it's an attempt to consolidate once again.
So some very interesting perspectives. And Devansh, I want you to hold on to the thought. Now, from there, I want to move to the issue of arrest and how the arrest has to be made. And one thing that is there, what has been introduced is specific provisions for handcuffing.
Yes.
Now, earlier there was guidelines laid down by the Supreme Court in the matter of D.K. Basu for handcuffing. The same judgment also observes that handcuffing violates all standard of decency, which should not be a norm and should be in very exceptional cases.
That's
I want to have your thoughts on whether it was required. Is this a necessary introduction to the Act?
So this is one of the provision of the statute which I think deserves a bit of criticism. Because whatever said and done, as way back in 1980, I think it was Justice Krishna Iyer's judgment also, which was the Shukla's case, where they had laid down certain guidelines of handcuff, and it always stood on the premises that there is a violation of human dignity when you are putting handcuffs on an individual. In fact, subsequently also the court had said that right against handcuffing was an unenumerated right under Article 20. So the whole idea of handcuffing, even jurisprudentially, was looked at something which is inconsistent with dignity. But because it was recognized in with that prism, there was still a safeguard under the old provision, which did not prescribe statutorily that you have the right of handcuffing in certain situations. You had to always give reasons because there was a presumption, constitutional presumption of violation of dignity. But now to give it a specific recognition, although yes, you have provided certain circumstances and certain criteria for exercising the right of handcuffing a person. But having said that, moment you have given it statutory recognition, the chance of human dignity getting violated also rises. I think it also leads to a bit of dent on the jurisprudence of Article 21, which was looking at handcuffing from the prism of negative, versus now there is a recognition that it is possible. So Women's Statute recognizes something, it is possible, even if there are checklists. I think it causes a bit of dent to the jurisprudence which anchors dignity to Article 21 and says now you have to give reasons, because the fundamental point earlier was handcuffing is violation of human dignity. Now there are exceptions to that, but unfortunately the exceptions are now in the statute, with the power to the police officer to exercise that power of handcuffing in certain other circumstances, also leaving it to his discretion or her discretion. That I think is something which is deserving of a criticism, because ultimately handcuffing can be easily exercised, and it will be indignified way of arresting somebody. Touching an arrest is one thing, but arresting, and then who is going to justify, and how will you lodge a complaint that there was no reason to handcuff an accused and humiliate him and drive him like a procession or in public, and versus your word versus police's word that no, there were good reasons why we had to put him under handcuff. That kind of debate is a meaningless debate once the humiliation has already been put upon you by your handcuff and taken. The humiliation is done. Now you can keep debating whether it was necessary or unnecessary. You can't undo that damage. So according to me, this was one introduction which according to me deserves criticism. In the overhauling of the statute, if at all they wanted to bring it in line, they should have left it without giving any additional power or giving it any statutory recognition. It's not that earlier the Supreme Court said that you cannot handcuff. The Supreme Court said you handcuff if there are reasons. So if they wanted to handcuff people who fall within the specified criteria of current subsection 3, that could have been done even without specifying it. That could have been the recorded reason for handcuffing. But by introduction, I think, according to me, there is a bit of a dent in that jurisprudence of Article 21, which according to me deserves criticism.
Ashwin, before you come in, I want you to, before you address this, also consider this provision which now in BNS talks about handcuffing, says that this has to be used in certain circumstances like hardened criminals, habitual offenders, in grave circumstances. Do you believe and agree with Devansh's really a dent in Article 21, because they have said that this is extreme or, it's for habitual offenders?
I think the negotiation between Article 21 and the criminal justice system has been going on for centuries, and I think it is likely to go on for all times. Okay. there is going to be a step forward, step back. You know, there is at one point of time, yes, sorry, at one stand, it is right that Article 21 and human dignity is extremely should be the foremost priority. But at the same time, I think the challenges faced by the police is also something that has to be factored in when they are dealing with these hardened criminals. Okay, I completely agree with Devansh that um, the, to reintroduce it by way of codifying it was uh, was maybe a little out of line, because I think much faith, and there are several law commission reports which also keep highlighting this issue. There are several Supreme Court judgments which keep highlighting the issue that much faith cannot be put on the police. The powers are really subjected to a lot of misuse. And that being a to a large extent admitted fact. Okay, uh, to allow the police to use their own discretion, okay, in a very blanket manner, okay, for violating the dignity that is promised under Article 21, could have been tapered by bringing in some kind of a judicial intervention. I feel, where it is required, where it is not. So I think, as I said, that the negotiation is ongoing. Blind faith on the police, although may be misplaced, but the challenges faced by the police are also a reality. So I think that negotiation or that navigation could have been done with some intervention from the court instead of codifying it in a manner, because the moment you codify it, okay, um, the court becomes to some extent obligated to consider it very strongly. So that could have, as I said, that could have been maybe tempered a little bit with judicial intervention. Anyways, as I said, I think these laws will always be subjective, because the Supreme Court has reiterated the importance of human dignity in Article 21, being the epitome of being at the topmost bracket when it comes to all the laws. So I think there is a possibility that through judicial intervention or through judicial jurisprudence, this provision does get addressed in a manner which is more logical, a lot more uh, Article 21 friendly, if I may.
Interesting, yes. Yes. So very quickly, because I want to touch upon two important topics. One is the bail and one is technology. I think I really want to touch upon these two, but very quickly on thoughts on bail, because bail is a subject which has even troubled the courts. And it's been time again, at least the Supreme Court has reiterated that bail should be a regular thing and jail should be an exception to the rule. But do you think the new laws are a step in the direction addressing the Supreme Court's concern that bail should be a rule?
Devansh, you want to answer that first?
No, go ahead.
Okay. No, I think to that extent, the new laws don't really dent it in any. Okay. I think the what you both have been highlighting, that whatever has come through judicial jurisprudence, okay, has been factored in to a large extent when it comes to these bail provisions. To a large extent, it has been seen that other than in serious offences, I think in offences which are not so serious in nature, the court has been dissuading the use of arrest, and therefore the old 41A, the Arnesh Kumar judgment, things like that. So where you don't directly, just because if you remember earlier, there was a time when even a 498A, okay, which was very loosely initiated at the instance of the lady's family, in whichever jurisdiction they stayed, they used to initiate an FIR, and then the police used to land up at the doorsteps of of the accused person, saying that aapke against FIR hai udhar chalo, So then, the Supreme Court had to like step in and bring in the Arnesh Kumar and all those other judgments. So to that extent, they are trying to dissuade the use of arrest, and there have been all those judgments in the Supreme Court by Justice Kaul, which are also which have laid down certain certain guidelines and all when it comes to arrests and how it should be, how the court should be conducting. I think to a large extent these laws uh, encompass the same thing. I think when it comes to, I think there is one area of confusion that has now brought in. I think it was an absolutely unnecessary area of, but again, it has great potential of confusion. That's the problem. For example, there are two things. One thing I'll tell you, like if you look at the current anticipatory bail provision, okay, uh, in the old CRPC, in the old CRPC, I mean the old CRPC, uh, the the moment you apply for bail, the court did have the discretion and does have the discretion to grant interim, okay, and that was codified in CRPC, okay. Now in the new law, okay, and that got codified after an amendment because the original language did not have much language about interims. So therefore, then there was judicial jurisprudence and then it was codified. Now, the current language goes back to the old language where there is no real language about interim. Okay. So I was arguing in the sessions court, and unfortunately, these are the first courts that one runs to, and the confusion starts there. When I was arguing one, the prosecutor got up and said, under the new law, there is no provision for an interim. For a moment, I was stumped. Like, really? I mean, do I really need to go back to this argument all over again? And fortunately, my team immediately pulled out a judgment of the Bombay High Court, which actually, just imagine that the courts now have to again waste time doing the same thing. The court had to reiterate the Bombay High Court Goa bench. I think I'll just give you the judgment saying had to reiterate that no, the courts will have the original jurisdiction of anticipatory bail and interim to be granted in an anticipatory bail. So, by just making a change without really, thinking it through, it just gave rise to a confusion which could have been, simply avoided. So similarly, the old law, the moment there is 50% of your sentence that you have undergone, okay, bail is to be granted. Now that was done again out of right to speedy trial and all the thing. Again, judicial jurisprudence, common cause, and all those. By the way, that judgment which I was talking about, the Bombay High Court, is called Chowgule and Company. That which says that okay, interim has to be done. But coming back to this, that this 50%, if you've undergone the 50% of your sentence, then bail could be granted. And this does not apply to serious offenses and things like which are punishable with life or death and things like that. Or where, for example, somebody is getting tried with murder, he will not be able to apply for this. Okay. Now, there are two provisions in this. One is the original provision for bail, and second is if you have undergone, right? Now, if I apply, now if you look at the judicial jurisprudence even in a murder case, if a person is has been behind bars as an under trial for anything between 6.5 to 7 years, okay, the court has been granting the person bail, okay, because there is his right to speedy trial is getting disturbed. Now, with this, I think there is a very strong possibility that the subordinate judiciary will start asking that if you do not qualify under the new provisions of 50%, you will not have the liberty to ask for bail if you have undergone 5 to 7 years.
Correct.
I think the apex court or the high court will have to step in again and clarify the situation all over again. I think all these kind of things could have been avoided by way of maybe finer language in the legislation. But again, as I said, a lot is left to be desired.
Devansh, I wanted to address this issue and specifically with your experience of appearing before the Supreme Courts. Now, Supreme Court has time again emphasized on the importance of granting bail in the right cases, not for the asking the right cases. However, we have seen the lower judiciary somewhere vary. It could be for various reasons they vary. Your perspective, how confidence can be given to the lower judiciary that in the right cases they should grant bail?
So, according to me, the bail is one jurisdiction which is ultimately driven by the courts. And appellate courts, either in state or the Supreme Court, they have a larger responsibility to set that tone. And what one would generally notice is that suppose there is as one may loosely call it, a season where bails are not being easily granted in the appellate courts or in the High Court or the Supreme Court. There are more bail applications where bails are being denied. It does have a percolating down effect where there is a bit of resistance by at the magistrate courts or sessions court to grant bail. Perhaps the approach therefore is that let us refuse the bail and let the High Court grant you the bail. Take it from the High Court. So therefore, where in a given case bail could have been granted, there is a bit of resistance. That resistance has nothing to do, may have nothing to do with the merits of the matter, but it may just have the resistance may come internally from a assessment of the courts, of the first court of first instance, of what is the judicial policy that is being communicated. So I think bail is one such which is largely driven by appellate courts, and the higher the court, the larger responsibility. So moment you have then judgments of the court where which are perceived as liberal, or more bails are being granted even in serious offences for stated reasons, for things like that there are a large number of witnesses which are yet to be examined, so the trial may take longer, so there is no reason to keep an accused behind bars, etc., and those obvious reasons that does have a percolating down messages, and one immediately starts seeing that then the court of first instance, sessions court, magistrate court do feel a little empowered in granting bail, perhaps because they carry the impression that now the judicial policy is communicating that bail must be liberal. And if they are going against the tide, their ability to go against the tide, if the communication is that bail ought to be denied, perhaps puts them on a back foot, because they may feel that their order of granting bail, where the judicial communication was to deny bail, may have a stricter scrutiny and may impact them. I think therefore, according to me, High Courts and the Supreme Court always carry the mantle of a proper communication of the bail jurisprudence. And if the more upholding of Article 21 High Court and Supreme Court is, the bail jurisprudence does work itself out. There is always a chance of few people letting few people who don't deserve bail gets bail. There is always a chance that one cannot avoid. But I think if the Supreme Court and the High Courts are generally liberal in granting bail, that I think is a healthier system than being stricter in granting bail, because large number of people do deserve bail, one can safely say, and there are very few people who don't deserve bail. But the communication generally tends to get reversed, and the sufferers are large number of people who are called victim of the system. So according to me, the responsibility of that communication is from the top down. Say, for example, recently, moment this new law was passed, the courts interpreted that provision of under trials who are first-time offenders and who are in fixed-term sentences completing 1/3 of their offences, which under the new law, they are allowed to be let off. the court intervened. Justice Hema Kohli passed that judgment in an order saying that extend this benefit to under trials even in the previous regime. Now, this only a Supreme Court could have done under Article 142 in a one shot, in a carte blanche basis. But I think small things like these, say, when the Supreme Court starts granting bail in PMLA cases or even any, UAPA cases on which are on stateable grounds, I think these messages do go by that there is no harm in being liberal in the bail jurisprudence. So I think that communication has direct effect, according to me.
Sorry, I'll just add a little bit if I could. See, I think the practical challenge is this, that I think when it comes to this bail jurisprudence, there are certain practical issues. Look, the immunity that the higher judiciary enjoys, the High Court and the Supreme Court, is not the immunity that the subordinate judiciary enjoys. Okay. To a large extent, the reality also is that the bar, there are elements in the bar who are loose-mouthed, okay, and also bad-mouthed, okay. And if in a sensitive matter, high-stake matter, if a discretion is used liberally, okay, people speak loosely and people speak badly, which many a times invites unnecessary attention upon a subordinate judiciary member.
Yes, that's yes.
And therefore, it deters the subordinate judiciary member from, acting very, very aggressively, or by in fact acting exactly in line with what the apex courts have laid down. I think that is also a very, very crucial aspect, when it comes to this. And therefore, the higher judiciary, therefore, is also the other thing is in the subordinate judiciary, when the investigation takes place, one person immediately runs for bail, right? And that is the initial period. So by the time he travels to the High Court, or by the time his matter actually gets called out in the High Court, the main episode or the period for investigation or keeping in custody is already lapsed, which is when the Sessions Court is actually dealing with it. So the High Court gets it at a time which is 2 months, 3 months down the line, whereas custody is actually not required, So therefore, that is another aspect where therefore the Supreme Court or the High Court says, now why do you need his custody? Chhod do, But one of the other things that I think could have been addressed when it comes, because now we have technology, is that the moment the bail takes place, okay, there is a process of a release rate that being communicated to the prisons, and then the person being released. So, what we have usually experienced is that after bail is granted by the court, it takes anything between 3 days to maybe even a week and more for the person to get released. In a recent matter, we managed to secure some bail in a detention matter. Now, he was in Nagpur, okay? By the time the court finished the process over here, and by the time the order got communicated to Nagpur, it was 15 days, after the court has passed its order, So, with use of technology, this could have been made much shorter. There could have been a shortcut that could have come. I think the Supreme Court and the Apex Court, as well as the High Courts, are working towards it, and that procedural aspect hopefully should get addressed soon.
So this is directly linked to, I want to now exactly come to the point of talking about technology and in criminal jurisprudence, and I have two pertinent questions separately for both of you. And now, because taking a lead from what Ashwin said, now Devansh, you're part of this e-prison project. I think somewhere covers what Ashwin mentioned. So I want you to delve a little more deep. I know we've overstepped the time, but I think this is important to educate our audience here and just tell them about Supreme Court's project of e-prison, where you're an amicus.
Right. So this e-prison project is basically, first is an e-prison portal. This e-prison portal is run under the auspice of Ministry of Home Affairs. It was developed by NIC. The main purpose of this e-prison portal is to collate the records of every individual who has any interaction with the prison, starting from the point where a person is arrested and taken to the magistrate and he is remanded to the prison with a remand custody warrant from that date until his entire life cycle under the criminal justice system. That that is the e-prison is the record keeper of that entire life cycle of each person. Now this today is holding close to 2 crore inmate records, which means from the time of its inception until now, the e-prison is now holding about 2 crore inmate records. And on a regular basis, thousands of people in India are entering and exiting jail. Now, this e-prison is attempting to keep track of that. Moment a person goes to jail, moment a person is out of jail, this is keeping track of that. It is keeping track of people who are coming to visit a person in jail, etc., etc. So in that sense, it's a beast which is collating the entire life cycle of an inmate from the time he is admitted to jail till his final release, either acquittal or remission, etc., etc., etc. This project e-prison is actually focusing on integration of the judicial record. So today we all are aware, all practicing lawyers, perhaps even law interns, that the judicial record is available on the internet. You can access a court order, download a court order, you know your case status through the portals which each courts maintain. And so the attempt is that there is integration of this judicial record with the prison record. The whole idea is basically to ensure delivery of justice as quickly as possible. Like the problem Ashwin mentioned, that a bail order is passed, but the communication of bail order has not taken place. For example, a FIR is registered. A person is taken to the magistrate and he is remanded. But the time between generation of this FIR and the communication of the FIR number to the prison authority, there is a time gap. So on the date of remand, if the FIR number is mentioned on the custody warrant issued by the court, then the prison authority is aware of the FIR number.
Right.
Otherwise, they have entered the person in jail based on the court case number. Now, what is happening is there is asymmetry. The court has a case number, police has an FIR number, prison has a jail number. Now, when a court is passing an order, it has to get delivered to the prison in the jail.
Yeah.
But how will it get delivered to the, systemically delivered to the prison, technologically, if the identification is not there? So between you and between us, if I need to send an email to either you or Ashwin, I am sending it to your email IDs. There is an identified address where it goes to. So the email communication is a great substitute of writing a letter. And therefore it serves its purpose of immediate delivery. So if a bail order has to reach the prison communicated, there has to be symmetry between technological identification of case number to the prison number.
Right.
The attempt that is being made under the e-prison project is to bring this whole thing on board and have a symmetrical case data which will be available so that mutual exchange and communication between prison, police, and judiciary happens without with absolutely reduced margin of error. Today, largely the entire delivery in most countries is physical. So there will be an order which will be passed and perhaps couriered, or a postman will take it, or whatever is the delivery mechanism physically delivered in the mountain of papers and record which is lying with the prison authority. Where is the time for them to pick up and enter? And what record should they enter? What is the most important information element that must be extracted and entered? That orientation is not there, and there is no time, because the idea is to deliver justice and release the person on bail. So in our interaction with the prison authority, which we have been carrying on for the last 1 year now, where we've now interacted with almost all the prison authorities in the country, and mind you, today, out of 1,368 jails in the country, 1,320 are connected with e-prison portal. So you have almost the entire prison record, prison system now getting connected with the e-prison model portal. So that is the project, which is an ongoing project, and we are trying that with the orders of the Supreme Court and the effort of prison authorities, state, NIC, etc., etc. We are trying to ensure that the criminal justice delivery system and administration of criminal justice becomes efficient. And that perhaps is also the spirit of the new law, that technology must help in delivery of justice. So in that sense, if e-prison project ultimately is successful in the way it is being worked out, then this efficiency will be in the spirit of the new statute, is our hope. But there is a lot to be achieved.
So
it's an ongoing project, order by order, year on year, it's going on. The courts are passing certain orders. Now the cases will come up again before this year ends. And more orders will be passed. And as soon as those orders are passed, they will be available. So then that point, one can see how far, what is the next step the court takes. So that's all I can speak about it right now.
So in my discussion of 1 hour with both of you, I think an amazing synergy has come about between the three pillars of a constitution. We have a new law in place from the legislature. We have the judiciary doing its bit in terms of, laying down rules, crystallizing the laws. We have the e-prison project by the courts to help the executive do its work well, to enable it to do its work well. So we see an amazing synergy of the three pillars, in criminal jurisprudence. Now, I have so much more. I think we have just snorkeled through this law, and I think there's much more that we have to discuss in deep dive, perhaps over a cup of coffee sometime later. We're running short of time, because I want, if there are more questions from our audience, I believe there are much more participants on the YouTube. Madhura, if there's any specific question you see on YouTube for participants here, feel free. I know we've overstepped, but happy to hear you.
Yeah, sure, Prachi. I'll also look up at the YouTube. We have a hand raised right here, Dr. Kamal. So, okay, there are some questions in the chat also, Prachi. I'll check the YouTube. Can you, in the meantime, just see the chat?
Yes. Yes. Yes, we have a question from Shraddha, who's a second-year law student, and her question is, with the new criminal laws incorporating provisions from special legislation such as UAPA, PMLA, and CA, there's a growing concern about the potential draconian nature of these reforms. So her question is, do you believe it's fair or appropriate to extend such stringent provisions into the general criminal framework? Ashwin, you want to take this?
Yeah, I think it's a very, very good question, rightly picked up. I think if we have to really discuss this, it's going to maybe take another session. But to briefly tell you, I think, look, to address very serious challenges that the society faces, one of the biggest challenges is that of terrorism. Okay, and the other one is of organized crime, right? So back in the days, the state of Maharashtra had come up with this legislation called Maharashtra Control of Organized Crime Act. Yeah. What the legislation predominantly aimed to do is completely break the backbone of the ecosystem of an organized crime system, okay, or a syndicate. Because it used to, and wherever it does, it still works within an ecosystem. Okay? So what it really aimed at doing is that anybody who even associates with the ecosystem should be brought in. Although it sounds draconian, but it really served a purpose. You see, Bombay today, I remember once upon a time in the 92, 93, you buy a Maruti 1000, an expensive car, and you used to get a call from a member of the organized crime syndicate for asking for money. That was the ecosystem that used to work, Anyway, so, and today, this kind of threat or this kind of evil in society has, at least in Bombay, to a large extent, been done away with. I think what was introduced through the MCOCA was that confessions were made admissible. There was a manner in which the confessions were to be recorded. There was interception that was allowed, and this whole organized crime organized crime syndicate, all these definitions were added. Plus, more importantly, there was a twin condition for bail that was added. Now, originally that was in TADA, and then from TADA it was taken to MCOCA. Then a similar legislation was introduced for terrorism by way of UAPA. What the new laws do, one important aspect in both these laws was that a sanction was required, and an officer of a certain degree could only or certain stature could only, a position could only investigate. But sanctions were required every now and then. For example, under the Telegraph Act, there was sanction required for interceptions. There was a sanction required from the commissioner to apply MCOCA to a certain offence, to see whether an organized crime syndicate is in place or no, things like that. Now, the language of this section has been picked up as is into the new legislations. However, there is no sanction that is required. For example, a UAPA, the state government also had to say, and a sanction was required again for the court to take cognizance. Now, in both the language, so organized crime has been introduced in the new law, Terrorism Act has been introduced in the new law, but none of them require a sanction. Now, in relation to the terrorism part, it is very funny because if you see the manner in which the legislation reads, and even earlier the IPC read, was that the offences are classified: offences against state, offences against human body, etc., etc. Terrorism has been made into an offence not against the state, but it comes under the chapter of offences against human body. There is no sanction required. Now, one can argue, wouldn't that be double jeopardy, because both are central legislations? They have introduced, therefore, that at the time of registering an FIR, the superintendent, the police officer will have to decide whether he wants to go with this legislation or the new legislation, that is UAPA or the BNS. Okay, he has to take a call over there. Now, the question that I ask myself is, today, if he wants to really misuse the law, can he not start an investigation under UAPA? Okay, if he wants to arrest someone, he starts something under UAPA. There are draconian twin conditions and all that thing, because of which there is no bail. He does that, and when it actually comes, that he finds out, then he knows, because he knows that no real offense is made up. There is nothing stopping him from watering it down from UAPA to BNSS. See, now, because the sanction was required for taking cognizance, if there is no case made out, there wouldn't have been any, the accused would have been left, would have been taken out of the whole trauma of the judicial proceeding, because there is no sanction. The moment there is no sanction, no cognizance, and therefore the judicial proceeding ends. But here, because there is no sanction, he can water it down to BNSS, and then it will be left to the accused to continue facing till he gets a discharge or notice. So that is that. Now, by removing the twin conditions for bail, the question is, are you really hitting the ecosystem? Now, just imagine a gangster gets arrested. Somebody from a syndicate gets arrested. Now, because of the twin conditions, they were not getting bail. And they used to come out by using 50% or whatever, undergone and things like that. Now here, if they immediately start getting bail and start coming out, they again start misusing it. So today, if the police officer wants to misuse if he's, and the nexus between an organized crime syndicate and police officers is not alien to the society, right? So if he really wants to help a gangster, he'll say, forget MCOCA, I'll put you under BNS. Now, in Maharashtra, BNSs and MCOCA both exist. In Rajasthan, in Gujarat, it exists. In Uttar Pradesh, it exists. All over the country, it does not exist. So, in areas where there is an organized crime syndicate operating, and there is no specialized, these legislations which deal with the ecosystem of organized crime system or syndicate, with the absence of twin conditions and things like those, I don't know how much in those other states will these offences really address the issue. Other than that, I think there is something that they brought in by way of petty organized crime, chain snatching and things like that. But again, no sanction required. no twin conditions. So, and given the fact that in a state like Maharashtra, there is MCOCA and the new legislation, wouldn't that be a double jeopardy,
Correct.
situation that would have to be addressed? Because, at the end of the day, both the sections are aiming at the same cause of action and the same offense.
Correct.
So how, all these questions will have to be answered. It's a very good question. I think a lot will have,
So we
we'll have
will
to see how.
So have another session. I agree. This needs to be, discussed in detail. Perhaps it is slightly, perhaps the last question for the evening. I think Dr. Sawal, are you there? I think I see a raised hand. Last question for the session.
Yeah, 1 second. I'm just making him a presenter so he can unmute and speak. Yeah, done. Are
Yes,
you around?
yes, whether I'm audible?
Yes.
Yes.
You are.
Okay, okay. Thank you. I'm Dr. Kamaria Sahawal, practicing in Allahabad High Court. My question is this provision of zero FIR. After that, police station have to re-register it as I, whether I think I may be right. So if it is so, then whether the purpose of introducing zero FIR is failed, but it has to re-register. I think it should be considered as registered at the first instance. What is the situation? Maybe make it clear.
Sorry, Devansh, I'll let you take it because I didn't catch the first half of the question.
I think the question relates, Ashwin, to zero FIR. Dr. Sehwal, good afternoon. Am I audible to you?
Yes, yes, yes. Obviously.
I think the zero FIR, you're right. The zero FIR concept is to avoid the technicality at the initial stage of jurisdiction of which police will ultimately have the jurisdiction. And it's not something which has been introduced right now. Zero FIR concept was always there. So moment it is a crime takes place, irrespective of the jurisdiction of the police, the focus is on the commission of the offense and thereafter identifying the right police station who will ultimately be able to take cognizance in terms of jurisdiction area wise. So in that context, I think a zero FIR at least enables a link between the place and the final police who will investigate the crime further. Because suppose the place of offense and ultimately the jurisdiction for other reason is different, or there are other factors which are still incomplete, then to recognize the place where the zero FIR as the first FIR and that is the FIR number might create more problems than solve it.
Correct.
Because that FIR number which will get generated will ultimately state in the end of the trial. And the whole law of preliminary investigation for registration of the final FIR is relevant for that FIR. The zero FIR sometimes it just works as an efficient system to ensure that there is some fallback or some link between the start and the final investigation. So I think there are some advantages rather than disadvantages, Dr. Sehwal, if I have answered your question in briefly.
Like, can I just add to that?
Yes, yes, yes.
Yes. Yeah. Very, very valid question, Dr. Sawal. I think the zero FR, the way we've seen it usually, that a certain police station may have and may have to maintain a separate register where they will have a separate number for a zero FR because they really don't investigate it. And then it will be sent because, Lalita Kumari says, and the jurisprudence says that an FR has to be registered immediately. So the system has to start immediately, the moment there is a cognizable offense, right? As early as possible. So the idea is the convenience of the informant is seen immediately. It is registered. Maybe a separate register will have to be maintained for that. And then when it goes to its relevant jurisdiction, the police registers an FIR and starts over there with a separate number. Like how we see when it comes to EOW in Bombay. So when an FIR gets registered in the local police station, there is a separate FIR number, and when it gets transferred to an EOW, the EOW, there's a separate number for it when it starts investigating for the same FIR. So, but on that note, I think we will have to wait, because I personally feel that there will be the courts will have to step in and crease out all these minor issues that are going to be cropping up again vis-a-vis the misuse of zero FIR, if at all it is possible, and how the record is to be maintained and how the record is to be supplied to the relevant police stations and the relevant courts and things like that. I think the courts will have to step in, and I think a lot needs to be done in that area.
I'm so
Thank you,
sure.
sir. Thank you.
Sorry, I'll have to. There are more questions pouring in for both of you, but I think we've overstepped our time. And I think, thank you very much. I mean, I will take these questions, and you can keep sending your questions to ILA. I think you can coordinate with Madhura, and perhaps something relevant, we can have them over again, the speakers, or share the questions with them. But thank you so much, both of you, for joining us on a Saturday morning. Thank you to the audience here and on YouTube for joining us. Had a lovely session. I think we, as I mentioned, we just snorkeled through this ocean of criminal jurisprudence. We need to deep dive on various aspects that came up. A lot of takeaways, at least for me, was this is act is more of a consolidation of various jurisprudence that has evolved over the years. We'll have to wait and watch to see how we are interpreting various provisions, like we touched upon the provision of handcuffing. We'll have to see how courts read it, interpret it, etc., etc. So yes, it's going to be a great journey for all practitioners to see how the provisions pan out. So thank you both very much. It was a pleasure having you both. And thank you
so much, Prachi.
Thank you, Prachi. Thank you, ILA, for the opportunity. And thank you, Ashwin. It was lovely to be a co-panel with you on this session. And thank you, all of you.
It was a privilege to be on the panel with you, Devansh. Thank you very much, Prachi. I think it's that as we started with this, that we really need to answer whether the overhaul of these new laws is something real, or as Ambedkar had said, that it actually only addresses a concept that India should usually avoid, is that of hero worship. So we really need to answer that whether Ambedkar's that particular aspect is being addressed whilst introducing these new laws. Thank you so much.
Over to you, Madhura.
Indeed, thank you so much for such an insightful webinar today and amazing conversations. I'm not a lawyer, but whatever I still could understand, it was really very insightful. So we will keep circulating the recordings and the shots and summaries of this event, and I'm very sure we'll keep getting more and more questions. People would want to interact. So as Prachi rightly said, that we will keep bugging all three of you with more questions. We could generate some series out of this, and we definitely look forward to staying engaged with all of you. Thank you.
Thank you. Have a good day, everyone.
Thanks. Bye.